Good morning, everybody. My name is Rod Dubrow-Marshall. I'm Deputy Vice-Chancellor at the University of Derby, and I'm co-editor of the International Journal of Celtic Studies. I'm disappointed, as many of you will be, that Al Scheflin is not giving this talk this morning, but I'm very happy to do my best to try and deliver his talk. I remember being inspired by Al Scheflin many years ago in Seattle in 2000 when he delivered a brilliant talk on the outer limits of influence. Some of that will come back into the talk today. I think I will be at the outer limits of my ability in trying to deliver Al Scheflin's talk this morning, but I'll do my best. Now, Al wanted to start by saying the following this morning in relation to delivering the Paul Martin Memorial Lecture. Dr. Paul Martin was a teacher, a treater, a trainer, and a testifier. It is this latter role, as an expert appearing in courts to testify about coercive mind manipulation, that serves as the subject of my talk. Inside the courtroom and outside of it as well, Paul fought diligently for every person's right to have a free mind in a free society. No battle is more important, and no warrior fought harder than Paul. Al continues, when I became president of ICSA in 2003, one of my first concerns was that we shift the dialogue away from the use of terms such as brainwashing or mind control or thought reform. It's not that I oppose these colourfully descriptive words and the frightening images they correctly conjured up. It's that I found them to be ineffective when used in courts of law. Brainwashing is not a judicial concept. There is no civil wrong, no tort of brainwashing, no crime of brainwashing. And brainwashing is not recognised in any jurisdiction as a defence to civil or criminal misconduct. According to Lund and Wilson, 1977, and I quote, no reported case in Anglo-American law has accepted brainwashing as a defence to criminal liability. I also had another concern in mind. Brainwashing, mind control, thought reform, and similar labels were initially used to describe real events involving real victims and real manipulators in places like Hungary, the Soviet Union, Korea, and China. And these had long stopped being recognisable historical references. Instead, they had passed into the realm of rhetoric, science fiction, and Hollywood horror movies. Even when used in reference to cultic groups, these words had acquired a derisive meaning that undercut any serious discussion of the important topic they raised: freedom of the mind from external malevolent manipulation. Furthermore, cult courts had difficulty giving scientific credence to political concepts like brainwashing. The term brainwashing was coined by Edward Hunter in the late 1940s as part of his job as a government propaganda specialist seeking to discredit communism. Its genesis was not scientific. Dr. Thomas Saz, an outspoken psychiatrist who often wrote cogently against the inherited wisdom of his profession, once colourfully said that one can no more wash another's brain than, quote, he can make him bleed with a cutting remark. For Saz and many who shared his view, the term brainwashing was simply a pejorative label applied in situations where, for other social or political reasons, we disapprove of the influence involved. For Saz, the analogy might be to homeless people who appear to act strangely. We use the process of involuntary commitment under his view to get them off the streets, not for their own good, but because we do not like to have them around us. In both situations, scientific and medical justifications are used to cover up a political agenda. If brainwashing is a political and not scientific concept, courts have no reason to admit expert testimony by mental health professionals. Even if the scientific hurdle involved brainwashing could be overcome, courts had no reason to find brainwashing ideas too prejudicial for juries to hear. And there's the example shown on the screen there of United States versus Fishman. And as noted by a federal appellate court in 2011, cult brainwashing arguments rarely succeed. They are often looked at by judges as, at best, a Hail Mary pass or an admission that no other recognised theory will help the client. Can anyone seriously doubt that innocent people fall prey to clever hucksters who enslave or cloud their minds in order to acquire their obedience and or their assets? These victims need relief, and in my view, they deserve it. But courts did not acknowledge any legal theory which permitted a remedy. And it was at that point that I remembered Florence Roizman. Florence was a lawyer in Washington, D.C. in the 1960s who represented tenants living in filthy, squalid apartment buildings owned by wealthy slumlords. In case after case, she successfully appealed to the hearts of the judges, but not to their minds. They told her, "This is a case of property law. The owners of the property have all their legal rights. Your clients do not." One day, however, everything changed. Florence entered the courtroom and said, "I'm not here arguing the law of property. I'm arguing under the law of contracts. My clients have a right to habitable dwellings, otherwise the contracts they signed are illusory." The judge answered, "Oh, you are arguing contract law. That is an entirely different thing." Notice that the facts of squalor in which her clients were living did not change. Only the legal theory she argued for redress. Florence won her case, and within a decade, every state in the country required landlords to supply tenants with decent sanitary dwellings because every contract for housing carried with it a judiciously created implied warrant of habitability. So I encouraged a shift away from brainwashing to the concept of undue influence, or in these cases, what we may call extreme influence. For more than 500 years, courts have been acquainted with undue influence as a legitimate legal concept created to provide a remedy for people who had become victims of con men and con women. The problem of judges not taking brainwashing claims seriously seemed solved. But the shift to an undue influence legal theory, not surprisingly, has encountered a few wrinkles that still need to be ironed out, and this is the topic of my talk this morning. The undue influence obstacles or problems. And the first of these is the unfamiliarity problem. Paradoxically, although the legal system has recognised undue influence for centuries, most judges have never seen the issue addressed in their courtrooms. The reason is that undue influence doctrine has been almost exclusively applied in cases involving financial shenanigans, most often involving people preparing their wills. Where there's money, there's manipulation. Interestingly, according to legal scholars, the creation of undue influence law was a direct response to the growing concern that the Church was taking advantage of the deathbed fears of the faithful for its own aggrandizement. As noted in an English case from 1708, there are no instances where men are so easily imposed upon as at the time of their dying under pretense of charity. Thus, the law of undue influence was largely developed as a means of protecting private wealth from the overreaching of overzealous religious clerics. As centuries passed, undue influence cases expanded beyond religion to include situations where financial interactions raised the possibility that the transfer of assets at the time of death might not have been the product of a free and voluntary choice. These will and financial cases involved assets, not ideas, and not identity. Today, the undue influence concept is being asked to serve a slightly different function. indoctrination, and not merely the transfer of wealth, plays a more prominent role. When we move from the physical realm of the exchange of money to the mental realm of the creation, alteration, and insertion of belief systems, other problems give judges serious concerns. So we move to the clarity problem. Two prominent legal scholars have correctly pointed out that undue influence is one of the most bothersome concepts in all of law. It cannot be precisely defined. This definitional issue is neither unusual nor is it fatal. Many concepts in law, such as due process of law, can only be understood after considerable interpretation based on an analysis of varying fact patterns brought before the courts. Indeed, the concept of reasonable doubt is no clearer, and many states forbid judges to even attempt to define it for juries because the definitions themselves are too confusing. The California Supreme Court defined undue influence as pressure brought to bear directly on the testamentary act sufficient to overcome the testator's free will, amounting in effect to coercion destroying the testator's free energy. This statement provides little guidance for when the undue influence doctrine will be applied, but one fact gives us a clue. Margaret Singer wrote that virtually anyone can be unduly influenced if the influences or techniques used against them are powerful enough. A California appellate court 80 years earlier, in a will contest case, is in agreement when they gave the following ruling. Soundness of mind and body does not imply immunity from undue influence. It may require greater ingenuity to unduly influence a person of sound mind and body, and more evidence may be required to show that such a person was overcome than in the case of one of weak body and mind. But history and experience teach that minds of strong men and women have often been overborne, and that they've been, by a mastermind, persuaded to consent to what in their sober and normal moments, and free from undue influence, they would not have done. I take these independent... Absolutely right. I take these independent comments to mean that everyone, almost, is potentially vulnerable. And that suggests to me that the undue influence doctrine should not be limited to cases involving wills, nor to cases involving other financial misdeeds. So we move to the sliding scale problem. When undue influence escapes from the fiscal confines in which it was largely contained, a more serious issue arises: where to draw the line. There are no clear demarcations as one passes from guidance to advice to education to suggestion to seduction to indoctrination to thought reform. This puts the judge in a difficult position of deciding on the basis of opinion, not law, because the law is not capable of us telling us in advance what is permissible and what is not, except at the extremes. What is helpful for me, and I hope it will be for you, is to focus not on the specific law, but rather on the policy behind the law. The law of undue influence, in my opinion, must find what I call the point of unacceptable interaction. This point occurs when you would say to yourself about someone's conduct, you just cannot treat people like that. And if you do, the law will step in and you will be punished. This perspective does not clarify anything, but for me it states the task. In all civil cases, the person who brings the lawsuit is saying that the status quo is wrong and the court should remedy it. That person has the burden of proving that the judge should step in and not just leave the parties in their current situation. No law could ever precisely and in advance define when the judge should act, because each fact pattern is unique. But I like the idea that an informal test should be, you just cannot treat people like that, and that the evidence must support that claim. So then we move to the paradox problem. It may be argued that the only true way to protect freedom of thought is to not interfere with it at all. This pits undue influence against freedom of choice. There is a strong preference in the law for 1, free will, 2, individual accountability, and 3, holding people responsible for their choices. For this reason, there is strong reluctance to expand the scope of justifications and excuses to override choices, no matter how unfortunate they may appear. So the paradox. Courts are asked to protect your freedom of choice by denying the choices you already made. The constitutional problem is next. Even if a judge would be inclined to step in and find undue influence, there is the problem of the First Amendment, which protects freedom of expression and freedom of religion. Fortunately, in many cases, the problem does not arise because behaviours, not beliefs, are at issue. In April of this year, the Nigerian Islamic extremist group Boko Haram kidnapped more than 200 teenage girls. A video was released showing approximately 150 of the girls attired in traditional Muslim dress, reciting or chanting verses from the Quran. Boko Haram leader Abu Bakr Shakal claimed that he had liberated the girls and that many of them have become Muslims, having been living as infidels. Would anyone claim that it would violate freedom of religion to rescue them and to undo the mental harm they have suffered, including the coerced indoctrination they've endured? There is no time to develop or discuss the intricacies of First Amendment law, other than to say that courts are wary of intruding in any case where religion is a factor. However, 2 current developments are worth mentioning because they may change the contours of how we think about religion and undue influence. The first is the ongoing issue of what is a religion. Scientology has qualified as a religion, but what about yoga? These facts, these cases are now pending. And what about Satanism? What about atheism? How far will courts go? How far are they willing to go in the religious status, becoming an increasing number and variety of organisations? Then we have the second and very recent development. And I know that had Al been here, he did wish to comment on the very recent Supreme Court decision in the so-called Hobby Lobby case, the 5-4 opinion in favour of both the Green family and the Han family, 2 for-profit corporations with sincerely held religious beliefs, who now, according to the Supreme Court ruling, do not have to provide a full range of contraceptives at no cost to their employees pursuant to the Affordable Care Act. This, in the words of the majority judgment, violates the contraceptive mandate, violates the Religious Freedom Act. And I know that Al did wish to comment on this landmark judgment. I'll merely cite the dissenting opinion of Ruth Bader Ginsburg when she said that reading the Act, and she's here referring, I believe, to the Religious Freedom Restoration Act, reading the Act expansively, as the court does, raises a host of Me Too questions. Can an employer in business for profit opt out of coverage for blood transfusions, vaccinations, antidepressants, or medications derived from pigs based on the employer's sincerely held religious beliefs opposing these medical practices? So I know that Al wanted to comment on the potential impact and implications of this judgment this week. He'd also prepared the following reference to a recent essay by Bill Moyers that raised the issue of whether there should be a corollary to the First Amendment, freedom of religion, and that corollary would be freedom from religion. And Moyers asked, how do we honour religious liberty without it becoming the liberty to impose moral beliefs on others? Our practical solution is protect freedom of religion and protect freedom from religion. And this topic is getting a lot of conversation, and there'll be a paper this afternoon that addresses these issues on religious cults, human rights and public policy, the secular perspective, by Dr. Stephen Much. I move on now further to the place of undue influence in the court system. And in the early will contest cases, which I referenced earlier, courts formulated a test for deciding whether undue influence had been applied to the testifier. In essence, the test articulates what a person must prove when claiming that undue influence had been applied. The test is simple but helpful because it paves the way for understanding why experts should be allowed to testify in undue influence cases and what they must say. And the SODR test, the SODR test, is shown on the slide. Number 1, the S, susceptibility to undue influence. O, opportunity to exert influence. Disposition to exert influence. And R, the result of the influence. And I've converted the SODR test into the social influence model, SIM, for use by experts testifying in court. And the 6 elements of the social influence model are the influencer, identity and status, the influencer's motives, their purpose, the influencer's methods, their techniques, the circumstances, the influencee's receptivity or vulnerability, and 6th, the consequences. My model was also influenced, in part, by a delightful portion of a poem in a children's book written by Rudyard Kipling. It is taught to journalists as a guide to writing a complete and compelling story. I found it useful as a structural guide to preparing expert testimony. So, my 6 servants. I keep 6 honest serving men. They taught me all I knew. Their names are what and why and when and how and where and who. And here is how Kipling's advice applies to SIM. So you have the influencer, the who, the influencer's motive, the why, the influencer's methods, the what and the how, the circumstances, the where and the when, influencer's receptivity, the who, and the consequences, what. So we may now take a quick look at the 6 elements in the model to add some detail. So the influencer, who, and this is the relationship to the influencee. This could be an authority figure, it could be a confidential relationship, an advisor, a family member, and so on. The influencer's motives, the purpose, the what and the how. So this could be financial gain, behavioural acquiescence, ideological adherence, ego gratification, political or social power. And the question is, who benefits? Beneficent, in that sense, versus malignant influence arises with this stage of the model. Then we have the influencer's methods, and there are many, but some examples are foot in the door, a small request, and then a larger one. The door in the face, a large request, and then a smaller one. Help me, and I'll help you. Won't you help? Don't you want to do the right thing? I'm really depending on you. This may be your only chance. Everyone's doing it. Don't be left behind. God has selected you. Love bombing, and then the grooming and the progression of seduction, the bait, the building of trust, sweetening the scam, and closing the fraud. And these relate very closely to Robert J. Lifton's 8 criteria for thought reform: milieu control, mystical manipulation, demand for purity, confession, sacred science, loading the language, doctrine over the person, and the dispensing of existence. And there's so much more that can be said about that, but there isn't time this morning. Similarly, Margaret Singer and Janja Lalich's 6 conditions for thought reform apply here also. Hide the agenda to control or change the person, control time, information, and the physical environment, create a sense of powerlessness, fear, and dependency, suppress old behaviors and attitudes, instill new behaviours and attitudes, and create a closed system of logic. And similarly, we can relate this to Steve Hassan's bite model, creating dependency and obedience to a leader or cause through behaviour control, information control, thought control, and also emotional control. These all were the influencers method stage of the SIM model. We move now to the circumstances stage of the SIM model, the where and the when. And here there is the location, the control of the physical environment, the milieu control already mentioned, the control of information, input and output, and access to independent advice, and the frequency, duration, and nature of the contacts. Then we have the influencee's receptivity, the who from the model, their personality type and individual differences between individuals. We have their hypnotic induction profile, HIP. We have the revised standard profile scales of hypnotic susceptibility, forms 1 and 2, for example, and Johnson's suggestibility scales. And there's 6 types of compliance with suggestions. One is source credibility, and this comes from things like expertise, training and experience, familiarity, charisma, authenticity, and sincerity. And indeed also perceived status and the awards that go with that. Second, post-event misinformation effect, interrogatory suggestibility, and also hypnotic suggestibility, the exposure to systematic and sustained influences, and finally, brainwashing, coercive persuasion, extreme influence as the final stage of that receptivity set of conditions. And then finally, the what, the consequences of the influence. And this is where there needs to be an examination of both the influencers and influencees' pre- and post-influence status. So this leads me to the possible return of brainwashing and the extension of undue influence as a concept. Events during the last decade and events in process as we speak may raise the interesting prospect that courts and others may be more responsive to claims of brainwashing and to claims of undue influence. Books such as Kathleen Taylor's Brainwashing, The Science of Thought Control, are supplying the scientific bases for arguing the validity of brainwashing theory. It's a great virtue of Professor Taylor's book is that she attempts to elevate the idea of brainwashing from the realm of political and religious discourse to the realm of brain science. Psychiatrists and psychologists have written extensively for decades about the psychodynamics of brainwashing techniques, but Taylor shifts the discussion to the domain of neuroscience to explain measurable brain changes in extreme influence situations. Thus, Taylor uniquely begins the process of describing brainwashing from inside the brain, rather than from the perspective of the techniques and methods utilised. If history is any guide, scientists, working privately or for government intelligence agencies, will find additional ways to do the near impossible. Study a topic where most types of research are unethical. And Taylor poses 5 questions in need of scientific investigation as shown on the screen. Number 1, why are some people more susceptible to extreme influence while others more easily resist it? Which techniques are most effective against which particular individuals? With brainwashing as an individual model, can mass mind control be orchestrated? Number 4, how close is science to the possibility of ultimate control of the mind? And number 5, how can a person resist brainwashing methods? Another recent book brings together substantial research on more benign aspects of suggestion and interaction. The Science of Social Influence in 2007 by Anthony Pracanis as the editor, and subsequent journal Influence make a good case for the fact that sufficient research data exists to support claims that expert testimony on the matters of influence, from the gentle to the coercive, can meet legal standards of admissibility. Put another way, psychology and sociology have now produced data-based and theory-tested explanations of how influence works, how it doesn't work, depending on the variables we discussed earlier. My point is that the days when brainwashing can be called mere rhetoric are coming to an end. Perhaps even more important is the expansion of interest in influence theory brought about by recent international events. Cult stories still arouse some interest in the media, but the headlines now involve terrorism and fundamentalism. The old questions, how could people do that? How could they act that way? How can they believe what they believe? Have returned to the front pages. In Saudi Arabia and other places as well, deprogramming sessions are conducted with former terrorists to undo the harm that their brainwashing has caused. ICSA has addressed these practices at several conferences in the past. If anything, the need for further dialogue and discussion has increased. Many governments are now more willing to hear from thought reform experts as problems in their countries increase due to extensive and intensive indoctrination of fundamentalist ideas. In short, unlike the past, where belonging to a cultic group might have been involuntary but not externally dangerous, in today's world there is much to fear unless brainwashing is understood and thwarted. Other headlines may bode well for the resurrection of interest in brainwashing and the understanding of the science behind it. Two examples immediately come to mind. First, after several decades of horrific child molestation by religious leaders and the cover-ups that shield the full extent of the problem, we now talk about the concept known as grooming. Grooming is not relegated just to child sexual abuse, nor to such abuse by priests. Studying the gradual process by which innocent youths are converted into victims sheds light on aspects of more comprehensive brainwashing processes. A second, though related example, is human trafficking, an international disgrace. My point is that all of a sudden, people who would never have had reason to talk with each other, the brainwashing specialists, the terrorism fighters, the child protectors, suddenly find that they have much common ground. We seem to be entering a new era of interest in thought reform and undue influence. Of course, I would have preferred to hope that we would not need to have to, but the attacks on mental freedom persist, and the need for the work that we do is greater than ever. In moving to my conclusion, this talk is dedicated to Dr. Paul Martin. It was also inspired by him. United States Supreme Court Justice Robert H. Jackson made a statement that is as true today as when he wrote it in 1950. But we must not forget that in our country are evangelists and zealots of many different political, economic, and religious persuasions, whose fanatical conviction is that all thought is divinely classified into two kinds, that which is their own and that which is false and dangerous. In 1983, I published an article entitled Freedom of the Mind as an International Human Rights Issue. I pointed out that while many international conventions protect freedom of the body from torture, precious few protect freedom of the mind from undue exploitation or manipulation. The First Amendment of the United States Constitution protects freedom of expression, but such protection is meaningless. Indeed, it is a cruel hoax if a mind is not free to express its own thoughts. The right to parrot another person's beliefs or to speak as their ventriloquist's dummy may not offend freedom of expression, but it does offend freedom of mind or conscience. I agree with Lord Thomas Robert Dewar's marvellous observation. Minds are like parachutes. They only function when they are open. The key to an open mind is doubt. The freedom to agree or disagree with any idea or belief as one sees fit. Nearly 70 years ago, Bergen Evans wisely observed, "Freedom of speech and freedom of action are meaningless without freedom to think. And there is no freedom to think without doubt." We have assembled here today to preserve and protect the most fundamental human right of them all, the right to be free to doubt, the right of every person to be the owner of his or her own mind. For me, this right precedes the First Amendment and becomes a necessary condition for its validity. Oxford University Professor Daniel N. Robinson, writing in 1973 on neuropsychology, made the following extraordinary comment. With Socrates, we witness the first example in the entire history of recorded thought of a prolonged, patient, and reasoned argument as a method of arriving at eternal truths. The older Orient, the Egyptians, the civilizations of Minos and Mycenae all had highly developed systems of thought. They could boast of advanced technologies and agricultural sciences, but none had philosophy. Pharaoh told the masses the law, but never explained the meaning of justice. Siddhartha Gautama, the Buddha, urged India to join an aesthetic simplicity that it may know the good life. But what is the end? What is good? What is true? No argument is offered. And even if the teachings could somehow be established as facts, they are not reasoned facts. With Socrates, the format changed. The opposition is given a voice, and arguments are forced to oblige in advocacy. I give you one philosophy after another, Socrates says to Theaetetus in the Phaedo, in order that you may come to know your own mind. Here is a statement of the objective. Not the happy life, not immortality, not riches, not popular regard, not practical successes, but to know one's own mind. In my mind, Paul Martin continued the work that Socrates started. I truly believe that. Thank you. Thanks, Alal. Yes, we are taking